Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we have some fun employment law, which is, whenever you see employment law, it's usually biased, being chosen by me specifically, just because that's sort of what I do right now. And we've got Potter and New Brunswick. So this is a case that talks about constructive dismissal. It's sort of the test currently right now that we have about constructive dismissal. And it went all the way up to the Supreme Court. So Zach, what do you know about constructive dismissal or about Potter and New Brunswick?
So constructive dismissal, I really like employment law, and I regret not taking it in law school because it's actually an area of law that I want to get into practicing. Put a little asterisk in that and hold me to that in like 5 years to see if I actually got around to learning enough about employment law to practice. But back to constructive dismissal and my learning about it. I learned all of my employment law information from when I was at Community Legal Aid, because one of the supervising lawyers there, I don't know if that's what she had done previously. I assume so because she's quite the expert on employment law. But I had an employment law file there. Anyways, she, told me about all the ways you can get dismissed and what constructive dismissal is and how it's, the change of your job so much so that, you're effectively forced out because things have changed and out of your control. Is that right? Is that what it is?
Yeah, yes, that's the gist of it. It's sort of, no one fired you, but the conditions of your employment have changed so as the employer has indicated they no longer want to be bound by the contract. So it's almost like they've repudiated it, sort of. So then you can leave and you can treat yourself as being constructively dismissed, which opens you up to the same the same damages scheme as if you were wrongfully dismissed, right? So it's still a dismissal. So you open yourself up to dismissal damages and how, reasonable notice, all that stuff. But no one actually fired you. It's just like...
it's weird like that.
Yeah, it's very strange. So this one's actually... It's weird even for constructive dismissal because, one, it's a lawyer. So lawyers tend to, be governed by their own statute. And this is even more so because it was the director of legal aid for all of New Brunswick. So his employment was actually determined by a statute specifically. So this case is weird because it's a constructive dismissal case for half of it, but the other half is also a strange administrative law decision about a very niche issue. Yeah, because technically he was hired, like his remuneration and hiring was done through an act because it fell under this legal aid act in New Brunswick. So it's a very weird, they get into this sort of like niche remuneration when it's through statute issue in the first part that I didn't actually learn in law school and am no expert on. So if any of this is wrong, I'm totally willing, I'm open to being corrected because this was just from my reading of it. And then the second half is about constructive dismissal. And it goes through the test and sort of lays everything out. And it's very, very fascinating. Constructive dismissal, I feel, is like one of those things, I would say like the average layperson doesn't know that that's a possibility.
No.
They just sort of are like, I can't take it anymore and I'm going to leave. And they don't sort of realize that like, no, like if you used to be whatever and they changed your job so much that it's now something else, that you're entitled to a remedy. And I feel like that's something that's not.
Right.
That's definitely not well known, especially because it's a common law remedy, right? Like it's not in the act, the ESA or anything anywhere. It's a common law remedy, which I feel people know even less about than statutory ones.
No, absolutely. Which always makes me laugh, like the irony of the common law is the idea of it, having to be known to everybody, but it's so amorphous and large. But like I think constructive dismissal is an area of common law that I think could be better expanded for employees. Just providing more information about it, I think would do a lot of people good because I think a lot of people's jobs change without them necessarily knowing. And then this kind of thing happens. And if everybody knew that this was a thing that could happen, it could be prevented from happening.
Yeah.
Right?
Yeah. And
ideally. Maybe I'm being an idealist.
No.
Again. I don't know.
As someone who works in employment adjacent stuff now, I would say that most people have no real idea what they're entitled to in employment. And lawyers especially, because we're exempt from a bunch of the act. We're exempt from a bunch of parts of the ESA, so it's even more confusing for us. This one's weird because I feel like if you read the facts of this, you'd be like, well, obviously I'm not the director of an entire governmental service for a whole province, so like constructive dismissal isn't applicable to me. We're going to put some other constructive dismissal stuff up on the podcast that has more terms a regular person would recognize, like someone, a company underwent restructuring and he suffered a huge demotion and they had to move and like the entire way the job worked completely changed. Like that's a little more recognizable for a regular person. I'd say Potter is good for the legal test, but in terms of like the facts, they're very rare. Like there could be at any time 10 provincial heads of legal aid in provinces. So like I really don't think it's going to come up that often, these specific facts. So I'd say it's good for facts. It's good for the law. It's not good for facts. Don't take this for facts. It's good for the law for constructive dismissal. And then otherwise, I'd go to other ones like Farber or other constructive dismissal cases for sort of a better example of what constructive dismissal looks like. But for the law, Potter is your boy. So take a listen, and we hope you enjoy. Potter and New Brunswick Legal Aid Services Commission. Heard May 12, 2014 and March 6, 2015. On appeal from the Court of Appeal for New Brunswick. Supreme Court of Canada. The judgment of Justices Abella, Rothstein, Moldaver, Karakatsanis, and Wagner was delivered by Justice Wagner. Part 1. Introduction. The issue in this appeal is whether and in what circumstances a non-unionized employee who is suspended with pay may claim to have been constructively dismissed. The claim involves the indefinite suspension of an employee with pay in the context of negotiations for a buyout of his contract of employment. The courts below found that the suspension did not amount to constructive dismissal, and that the employee, Mr. Potter, had therefore repudiated the contract when he brought an action for constructive dismissal. For the reasons that follow, I respectfully disagree. Mr. Potter's employer, the New Brunswick Legal Aid Services Commission, lacked the authority, whether express or implied, to suspend him indefinitely with pay for the reasons it gave. I find that Mr. Potter was constructively dismissed and that he is accordingly entitled to damages for wrongful dismissal. I would adopt the trial judge's provisional assessment of those damages, with the exception that the pension benefits Mr. Potter received should not be deducted from them. Part 2. Background and Judicial History. A. Background. Mr. Potter is a lawyer who was admitted to the Law Society of New Brunswick in 1977. After serving in various positions primarily with the province of New Brunswick, Mr. Potter became the province's interim director of legal aid in 1993. He remained in that position until 2005, when the Legal Aid Act was amended to create a new scheme under which staff lawyers would represent litigants. Under the former system, lawyers in private practice had been paid for performing legal work. The amendments also created the position of Executive Director of Legal Aid. On December 12, 2005, the day the amendments were proclaimed, the Board of Directors of the newly created commission nominated Mr. Potter for appointment as Executive Director. The Lieutenant Governor in Council formally appointed him to that office on March 16, 2006, by means of Order in Council 2006-85. The appointment was for a 7-year term that was to expire on December 12, 2012. Mr. Potter's appointment as the Executive Director was governed by Section 39 of the Legal Aid Act, which reads as follows. Executive Director. The Lieutenant Governor in Council shall appoint as the Executive Director of Legal Aid the person nominated by the Board. The Board shall establish the terms and conditions of the Executive Director's appointment. An Executive Director shall hold office for a term of 7 years from the date of his or her appointment. The appointment of an Executive Director may be revoked for cause by the Lieutenant Governor in Council. An Executive Director is eligible for reappointment and subsections 1 to 4 apply with the necessary modifications in respect of reappointment. The Executive Director shall perform the duties and may exercise the powers imposed on the Executive Director by this part, the regulations, or the Board. The Board had also established the terms and conditions of Mr. Potter's appointment as required by Section 39(2), in a resolution dated December 12, 2005 that included provisions on remuneration, insurance benefits, pension benefits, vacation and sick leave, and a vehicle allowance. Section 39(6) provides that certain powers and duties are attributed to the Executive Director by the Legal Aid Act itself, by the regulations, or by the Board. The powers and duties attributed by the Act include the following: the hiring of employees, contracting with lawyers not employed by the Commission, directing employees and contractors, assisting the Legal Aid Committee with investigations, appointing area legal aid committees, acting as one of the signing officers of the Legal Aid Fund, administering Legal Aid New Brunswick in accordance with Part 3, the regulations, and any policies established under Part 3 and the regulations, and, subject to board approval, establishing policies to govern the administration of the plan. In October 2009, after Mr. Potter had completed nearly 4 years of his 7-year contract, his physician advised him to take time off for medical reasons. Although initially 1 month, the period of his medical leave was subsequently extended, first to January 4th, 2010, and then to January 18th, 2010. The second extension was accompanied by a note in which Mr. Potter's physician observed that he needs to be reassessed before going back. In his absence, Mr. Potter delegated his powers and duties to Peter Corey, the Commission's Director of Criminal Operations. Before then, in the spring of 2009, Mr. Potter and the board had begun to negotiate a buyout of his contract. If successful, the process would have culminated in Mr. Potter's resignation in exchange for an agreed-upon compensation package. On January 5th, 2010, the board decided, without alerting Mr. Potter, that if the buyout negotiations were not resolved before January 11th, it would request that the Lieutenant Governor and Council revoke Mr. Potter's appointment for cause, pursuant to Section 39(4) of the Legal Aid Act. Its decision was reflected in the following resolution. Quote, "The Chair shall send correspondence to the Minister of Justice with the CC to the Deputy Minister, requesting that David Potter's appointment as Executive Director of the Legal Aid Services Commission be revoked for cause. Such letter to be sent only if Gordon Petrie, QC, is unable to negotiate a resolution with Mr. Potter before Monday, January 11th, 2010, on the basis that Mr. Potter receive no more than 18 months' salary, including his retirement allowance." End quote. On January 11th, Ubernost to Mr. Potter, the chairperson of the board sent a letter to the Minister of Justice recommending that Mr. Potter be dismissed for cause and outlining in general terms the grounds for dismissal. Also on January 11th, Counsel for the Commission sent a letter to Counsel for Mr. Potter advising him that Mr. Potter was not to return to work until further direction. Quote, "Our client, the Legal Aid Services Commission, has instructed us to advise you that David Potter ought not to return to the workplace until further direction from the Commission. He will continue to be paid until instructed otherwise." End quote. On January 12th, Counsel for Mr. Potter replied, acknowledging receipt of that letter and requesting clarification of the Commission's instructions. Quote, "I have received your letter dated January 11th, 2010. I note the use of the phrase that Mr. Potter ought not to return to the workplace. That phrasing could be interpreted as advisory as opposed to directive. Given that Mr. Potter occupies a position which sets out a statutory obligation to perform the duties of his position, can you confirm whether the board has suspended Mr. Potter?" End quote. On January 13th, Counsel for the Commission confirmed that the statement was directive. Quote, "I am surprised that you and your client are confused. He is not to return to work until further notice." End quote. Mr. Potter was not aware of the board's letter recommending that he be dismissed for cause, and there is no evidence that the Lieutenant Governor and Council took any steps towards acting on the recommendation. Mr. Potter's sick leave was due to expire on January 18th, 2010, but having received the instruction of January 11th, as clarified in the letter of January 13th, he did not return to work. The board delegated the powers and duties of the Executive Director to Mr. Corey, to whom Mr. Potter had previously delegated them. On March 9th, 2010, 8 weeks after the board's instruction to stay away from the workplace and 7 weeks after Mr. Potter had been scheduled to return from sick leave, Mr. Potter commenced an action for constructive dismissal. He claimed the following relief: damages with respect to salary and benefits through December 12, 2012, the end of his term, general damages, Damages arising from the manner of dismissal, like those defined in Wallace and United Grain Growers Limited. A declaration that the board had no authority to suspend Mr. Potter. A declaration that the board had unlawfully obstructed Mr. Potter from exercising his statutory powers. Declarations that the board had unlawfully usurped the functions of both the executive director and the lieutenant governor in council by delegating those statutory powers to someone who had not been duly appointed and post-judgment interest. In response, the board stopped Mr. Potter's salary and benefits. Counsel for the commission advised his counsel of this in a letter of March 15, 2010. Quote, based on your client's legal action claiming constructive dismissal, our client takes the position that he has effectively resigned his position. Therefore, salary and benefits were stopped on March 9, 2010. Furthermore, he is directed to return to the commission the following items: A. BlackBerry, B. Cell phone, C. Home computer, and D. OnStar. We thank you for your anticipated cooperation. End quote. Counsel for Mr. Potter replied that same day, indicating that Mr. Potter had not resigned. Quote, to be clear, Mr. Potter has not resigned from any position or office, and your client is incorrect in that regard. End quote. The letter went on to say that Mr. Potter might be forced to draw on his pension, retirements, and severance and other benefits, but that his doing so would not constitute acquiescence in the Commission's view that he had resigned. A similar letter of clarification was sent to the Deputy Minister of Justice, also on March 15th. On March 23, 2010, Counsel for Mr. Potter notified the Deputy Minister in a letter that was copied to Counsel for the Commission that Mr. Potter was taking steps to draw on his pension and other benefits for financial reasons. This letter went as follows. Quote, however, we ask that your office take immediate steps to direct reinstatement of his salary and benefits until the matter is finally determined. As you are aware, Mr. Potter's appointment to his office by order in council remains in effect. The Commission has deprived him of his duties and now his pay. That action is reserved exclusively to the Crown upon showing its case. We ask for your intervention as noted. Again, as set out in previous correspondence, Mr. Potter has not resigned his office or refused to carry out the duties of his office. The fact that Mr. Potter now feels he must access his pension plan or other benefits ought not to be considered in any way as a resignation of his office or duties, but only as a matter of financial necessity forced upon him by the actions of the Commission. End quote. B. New Brunswick Court of Queen's Bench. Justice Grant found that the board had the statutory authority under the Legal Aid Act to place Mr. Potter on administrative suspension with pay. Although the Act clearly grants the Lieutenant Governor and Council the authority to retain and dismiss the Executive Director, Justice Grant found that Section 39(6) of the Act gives the board a broad discretion to supervise the Executive Director in the performance of his or her duties, and that this discretion includes the power of suspension. On the central question of constructive dismissal, Justice Grant held that Mr. Potter's administrative suspension with pay did not, in the circumstances of the case, despite its indefinite term, constitute constructive dismissal. The question was whether, by taking Mr. Potter's duties and powers away from him for an indefinite period of time, the board had repudiated his contract of employment. Justice Grant held that this question should be examined in light of what Mr. Potter knew at the time of what he alleged to be a constructive dismissal, because he could hardly allege that he was constructively dismissed based on something the employer did ubernost to him. Since there was no evidence that the board had advised Mr. Potter that it intended to arrange for his termination, he could not rely on the board's letter to the Minister of Justice recommending termination for cause. If the situation is viewed only in light of what Mr. Potter knew at the time he commenced his action, although he was clearly suspended from work and unable to perform his duties, the Commission had not done or said anything that would lead an objective observer to conclude that they had removed those duties from him permanently. On the contrary, Justice Grant found that Mr. Potter and the board had been engaged in ongoing discussions about a buyout of his contract, and that an administrative suspension pending resolution of these discussions was consistent with the relationship between the parties. In suspending Mr. Potter, the board was buying time for further negotiations, and while the duration of the suspension was becoming lengthy, there is nothing in the record before me to indicate that a reasonable person looking at the matter objectively would have concluded that the employer had repudiated the contract. Justice Grant noted that if Mr. Potter was concerned about the indefinite nature of the suspension, he could have corresponded with the board or given them notice that after a certain date he would consider himself to have been constructively dismissed, rather than taking the precipitous course or making the dramatic move of starting legal proceedings. Justice Grant distinguished the situation of suspension pending negotiations from the one in Park and Parsons Brown and Company, in which a decision to strip an employee of all his powers and duties had been found to amount to constructive dismissal. Justice Grant went on to find that by commencing an action for constructive dismissal, Mr. Potter had effectively destroyed any chance of a productive working relationship between the parties, and had therefore repudiated the employment contract by what amounted to a resignation. In case his decision on the constructive dismissal issue should be reversed on appeal, Justice Grant also made a provisional assessment of damages. He found that any damages would be measured by calculating the balance of salary and benefits to which Mr. Potter would be entitled from the date the board stopped paying him until the date his term was to expire. He held that by virtue of Section 16 of the Public Service Superannuation Act, Mr. Potter would not be entitled to collect both his salary and pension benefits, and that any amounts received or to be received under his pension would be deducted from the award of damages. Justice Grant added that Mr. Potter had no duty to mitigate his damages by seeking other employment, given his age, and the small likelihood he would find any employment, let alone a job analogous to the position. Finally, he refused to award Wallace-type damages or general damages, which were being claimed for the manner of the alleged dismissal, as he found no evidence that Mr. Potter had been mistreated or that the board had acted in bad faith. Subpart C. New Brunswick Court of Appeal. Chief Justice Drapeau, writing for a unanimous panel of the New Brunswick Court of Appeal, dismissed the appeal. He began by addressing the question whether the Commission was truly Mr. Potter's employer, or whether the employer was instead the Crown, which was the only entity empowered to appoint, reappoint, or dismiss the executive director. In his view, the action for constructive dismissal could not succeed if the Crown was the true employer. After giving reasons in support of this position, Chief Justice Drapeau declined to dispose of the appeal on this ground, as it had not been pursued by the parties. Instead, he confirmed Justice Grant's interpretation to the effect that the Legal Aid Act confers on the board power over all aspects of the executive director's appointment, other than his or her appointment, reappointment, and removal. The board's discretion to supervise the executive director includes the power of administrative suspension. Chief Justice Drapeau held that the trial judge had committed no reversible error in concluding that Mr. Potter had not been constructively dismissed. He noted that the question whether an indefinite suspension with pay constitutes constructive dismissal depends on the circumstances of the case. The test, as this court has stated in Farber and Royal Trust Company, is whether the suspension constitutes a fundamental or substantial change to an employee's contract of employment. To this end, Chief Justice Drapeau applied the following useful list of factors that had been formulated in Devlin and NEMI Northern Energy and Mining Company. Quote, 1. The duration of the suspension. 2. Whether someone was appointed to replace the suspended employee. 3. Whether the employee was asked for his or her keys. 4. Whether the employee continued to be paid and receive benefits. 5. Whether there is evidence that the employer intended to terminate the employee at that time. And 6. Whether the employer suspended the employee in good faith, for example, for bona fide business reasons. For Chief Justice Drapeau, although the indefinite duration of the suspension weighed in favor of a finding that the suspension constituted constructive dismissal, it did not trump the other factors, all of which supported Justice Grant's amply justified conclusion that Mr. Potter had not been constructively dismissed. Thus, no one was formally appointed to replace Mr. Potter during his suspension, and the person tasked with assuming his responsibilities had been designated by Mr. Potter himself upon going on sick leave. Nor was Mr. Potter asked to turn in his BlackBerry, cell phone, laptop, and OnStar until after he had launched his action. Mr. Potter continued to be paid his full salary and to be eligible for benefits during the period of the suspension. The board did not intend to terminate Mr. Potter, as it was operating under the honest conviction that only the Lieutenant Governor in Council could prescribe termination. Finally, the board acted in good faith in suspending Mr. Potter, as was shown by the unchallenged testimony of Dr. Doherty, the board's vice chair. Chief Justice Drapeau also suggested, although without deciding this point, that Justice Grant may have erred by limiting his assessment to facts known to Mr. Potter at the time of his alleged constructive dismissal. Quote, "It may be that the trial judge was required to consider all of the circumstances, including those unknown to Mr. Potter, prior to commencing his action." End quote. He nevertheless stated that such an error would have been wholly harmless, because had Justice Grant considered the board's letter to the Minister of Justice recommending that Mr. Potter's employment be terminated, this would only have confirmed that the board understood it could not itself terminate Mr. Potter. Chief Justice Drapeau went on to hold that, by suing for damages for constructive dismissal, Mr. Potter had terminated not only his employment with the board, but also his appointment by the Lieutenant Governor in Council. Although Mr. Potter had cautioned the board that he was prepared to continue to perform his duties, and that the filing of his action did not constitute a resignation, he had done so only after taking legal action, in an attempt to avoid the legal consequences that flowed from his lawsuit. In Chief Justice Drapeau's view, Mr. Potter had, by equating his indefinite administrative suspension with pay to a constructive dismissal, elected to repudiate his contract of employment and resign. His resignation had been effected by operation of law, and it had to be what Mr. Potter intended, since it was corollary to his action for constructive dismissal. Chief Justice Drapeau did not address the issues of damages in his reasons. Part 3. Issues. This issue raises 3 questions, which I will answer in turn. 1. Did the trial judge err in concluding that Mr. Potter was not constructively dismissed? 2. If Mr. Potter was not constructively dismissed, did the trial judge err in concluding that Mr. Potter resigned when he launched his action in damages? 3. If Mr. Potter was constructively dismissed, did the trial judge err in finding that the amounts Mr. Potter received under his pension should be deducted from his damages for wrongful dismissal? Part 4. Analysis. A. Was Mr. Potter constructively dismissed? When an employer's conduct evinces an intention to no longer be bound by the employment contract, the employee has the choice of either accepting that conduct or changes made by the employer, or treating the contract or changes as a repudiation of the contract by the employer and suing for wrongful dismissal. This was clearly stated in Farber, the leading case on the law of constructive dismissal in Canada. Since the employee has not been formally dismissed, the employer's act is referred to as constructive dismissal. The word constructive indicates that the dismissal is a legal construct. The employer's act is treated as a dismissal because of the way it is characterized by the law. The burden rests on the employee to establish that he or she has been constructively dismissed. If the employee is successful, he or she is then entitled to damages in lieu of reasonable notice of termination. In Farber, the court surveyed both the common law and the civil law jurisprudence in this regard. The solutions adopted and principles applied in both 2 legal systems are very similar. In both, the purpose of the inquiry is to determine whether the employer's act evinced an intention no longer to be bound by the contract. Given that employment contracts are dynamic in comparison with commercial contracts, courts have properly taken a flexible approach in determining whether the employer's conduct evinced an intention no longer to be bound by the contract. There are 2 branches of the test that have emerged. Most often, the court must first identify an express or implied contract term that has been breached, and then determine whether that breach was sufficiently serious to constitute constructive dismissal. Typically, the breach in question involves changes to the employee's compensation, work assignments, or place of work that are both unilateral and substantial. In the words of Justice McCarty in Ruble Bronze, the question is ever one of degree. However, an employer's conduct will also constitute constructive dismissal if it more generally shows that the employer intended not to be bound by the contract. In applying Farber, courts have held that an employee can be found to have been constructively dismissed without identifying a specific term that was breached if the employer's treatment of the employee made continued employment intolerable. This approach is necessarily retrospective, as it requires consideration of the cumulative effect of past acts by the employer and the determination of whether those acts evinced the intention to no longer be bound by the contract. The first branch of the test for constructive dismissal, the one that requires a review of specific terms of the contract, has 2 steps. First, the employer's unilateral change must be found to constitute a breach of the employment contract, and, second, if it does constitute such a breach, it must be found to substantially alter an essential term of the contract. Often, the first step of the test will require little analysis, as the breach will be obvious. Where the breach is less obvious, however, as is often the case with suspensions, a more careful analysis may be required. In Farber, Justice Gonthier identified such a change as a fundamental breach. The term fundamental breach has taken on a specific meaning in the context of exclusionary or exculpatory clauses. To avoid confusion, I will therefore use the term substantial breach to refer to breaches of this nature. The standard nevertheless remains unchanged. A finding of constructive dismissal requires that the employer's acts and conduct evince an intention to no longer be bound by the contract. The 2-step approach to the first branch of the test for constructive dismissal is not a departure from the approach adopted in Farber. Rather, the situation in Farber was one in which the identification of a breach required only a cursory analysis. The emphasis in Farber was on the second step of the branch, as the evidentiary foundation for the perceived magnitude of the breach was the key issue in that case. However, the identification of a unilateral act that amounted to a breach of the contract was implicit in the court's reasoning. In many cases, this will be sufficient. The case at bar, however, is one in which the claim can be properly resolved only after both steps of the analysis have been completed. At the first step of the analysis, the court must determine objectively whether a breach has occurred. To do so, it must ascertain whether the employer has unilaterally changed the contract. If an express or implied term gives the employer the authority to make the change, or if the employee consents to or acquiesces in it, the change is not a unilateral act and therefore will not constitute a breach. If so, it does not amount to constructive dismissal. Moreover, to qualify as a breach, the change must be detrimental to the employee. This first step of the analysis involves a distinct inquiry from the one that must be carried out to determine whether the breach is substantial, although the two have often been conflated by courts in the constructive dismissal context. Justice Gonthier conducted this inquiry in Farber, in which an employee had been offered a new position that was found to constitute a demotion. He stated that the issue of whether there has been a demotion must be determined objectively by comparing the positions in question and their attributes. Once it has been objectively established that a breach has occurred, the court must turn to the second step of the analysis and ask whether, at the time the breach occurred, a reasonable person in the same situation as the employee would have felt that the essential terms of the employment contract were being substantially changed. A breach that is minor in that it could not be perceived as having substantially changed an essential term of the contract does not amount to constructive dismissal. The kinds of changes that meet these criteria will depend on the facts of the case being considered, so one cannot generalize. In each case, determining whether an employee has been constructively dismissed is a highly fact-driven exercise, in which the court must determine whether the changes are reasonable and whether they are within the scope of the employee's job description or employment contract. Although the test for constructive dismissal does not vary depending on the nature of the alleged breach, how it is applied will nevertheless reflect the distinct factual circumstances of each claim. The uniqueness of the application of the first branch of the test is evident in cases involving administrative suspensions. In all cases, the primary burden will be on the employee to establish constructive dismissal, but where an administrative suspension is at issue, the board will necessarily shift to the employer, which must then show that the suspension is justified. If the employer cannot do so, a breach will have been established, and the burden will shift back to the employee at the second step of the analysis. The second branch of the test for constructive dismissal necessarily requires a different approach. In cases in which this branch of the test applies, constructive dismissal consists of conduct that, when viewed in light of all the circumstances, would lead a reasonable person to conclude that the employer no longer intended to be bound by the terms of the contract. The employee is not required to point to an actual, specific, substantial change in compensation, work assignments, or so on, that on its own constitutes a substantial breach. The focus is on whether a course of conduct pursued by the employer evinces an intention no longer to be bound by the contract. A course of conduct that does evince such an intention amounts cumulatively to an actual breach. Justice Gonthier said the following in this regard in Farber, quote, "In cases of constructive dismissal, the courts in the common law provinces have applied the general principle that where one party to a contract demonstrates an intention to no longer be bound by it, that party is committing a fundamental breach of the contract that results in its termination." End quote. Thus, constructive dismissal can take two forms: that of a single unilateral act that breaches an essential term of the contract, or that a series of acts that, taken together, show that the employer no longer intended to be bound by the contract. The distinction between these two forms of constructive dismissal was clearly expressed by Lord Denning in a leading English case, Western Excavating Limited and Sharp. First of all, an employer's conduct may amount to constructive dismissal if it shows that he no longer intends to be bound by one or more of the essential terms of the contract. But the employer's conduct may also amount to constructive dismissal if it constitutes a significant breach going to the root of the contract of employment. In either case, the employer's perceived intention no longer to be bound by the contract is taken to give rise to a breach. In applying the first branch of the test for constructive dismissal to the facts of the case at bar, this court must ask first whether the board's suspension of Mr. Potter amounted to a breach of the employment contract. For this, it must determine whether the suspension was a unilateral act. On its face, the board's decision to suspend Mr. Potter was clearly unilateral, since he did not consent to the suspension. But the Commission counters that the suspension does not evince an intention no longer to be bound by the contract, as it was authorized by an express or implied term of the contract, which is a way of saying that Mr. Potter consented to such a change by signing the contract. I agree that the question whether the suspension amounted to constructive dismissal turns in part on whether it was authorized by the contract. If there was an express or implied term that authorized the board to suspend Mr. Potter as it did, then there was no unilateral act and therefore no breach of the contract, let alone a substantial change to the essential terms of the contract, and the constructive dismissal claim must fail. If, however, the suspension was not authorized by the contract, then it satisfies the requirements of the first step of this branch of the test, that is, it constitutes a unilateral change that amounts to a breach of the contract. It would then be necessary to turn to the second step and ask whether the board's unilateral decision to suspend Mr. Potter could reasonably be perceived as having substantially changed the essential terms of the contract. It is clear that a suspension can amount to constructive dismissal. In determining whether the unauthorized suspension constituted a substantial breach, the court must consider whether a reasonable person in the employee's circumstances would have perceived, inter alia, that the employer was acting in good faith to protect a legitimate business interest, and that the employer's act had a minimal impact on him or her in terms of the duration of the suspension. With respect, the trial judge erred in failing to consider the two steps of the inquiry independently. Applying the principles discussed above to the facts of the instant case, I find that Mr. Potter was constructively dismissed by the board. In light of the indefinite duration of the suspension, of the fact that the Commission failed to act in good faith insofar as it withheld valid business reasons from Mr. Potter, and of the Commission's concealed intention to have Mr. Potter terminated, I respectfully find that the trial judge erred in concluding that the suspension was authorized by the contract of employment. Moreover, for the reasons set out below, I find that this breach of the contract amounted to a substantial change to the essential terms of the contract that was imposed unilaterally by the employer. With respect, I cannot agree with Justice Cromwell's assertion that this analysis is unnecessary, or that constructive dismissal can be established on the basis of the second branch of the test. First, little, if any, support can be found for the position that a reasonable person in Mr. Potter's situation would conclude that the suspension evinced an intention on the employer's part to no longer be bound by the contract without addressing the question of whether the suspension was authorized. If the contract expressly or impliedly authorized the suspension in the manner in which it was carried out, this cannot contribute to the determination that a course of conduct amounted to a breach. The same is true of the buyout negotiations, which, as far as Mr. Potter knew, were being conducted in good faith. Moreover, although this is not central to Justice Cromwell's analysis, the Board's letter to the Minister of Justice is not, in light of the discussion that follows, relevant to the analysis under this branch. The only relevant evidence is therefore the letter advising Mr. Potter that he would continue to be paid until instructed otherwise. I concede that this letter unnecessarily introduced some uncertainty into Mr. Potter's employment situation. Nevertheless, a reasonable person in his situation could not have concluded on this basis that the Commission's conduct evinced a clear intention no longer to be bound by the contract. I will begin by addressing two preliminary issues. First, I will dispel the doubts expressed by the Court of Appeal regarding the existence of an employment relationship between the Commission and Mr. Potter. Second, I will review the terms of the contract to determine whether there was an express grant to the Board of authority to suspend Mr. Potter. Having concluded that there was no such express grant, I will then turn to the central question in this appeal, whether there was an implied grant of authority to do so. The trial judge found that the suspension was authorized, but I am of the view that this finding was based on an erroneous understanding of the law applicable to suspensions in the constructive dismissal context. My conclusion is that the Board did not have the authority, whether expressed or implied, to suspend Mr. Potter indefinitely with pay for the reasons it gave, and that the suspension was a substantial change that amounted to constructive dismissal. 1. The employment relationship between Mr. Potter and the Commission. The Court of Appeal held that if the Commission was not Mr. Potter's employer, his action could not succeed as a matter of common sense and law. Although Chief Justice Drapeau accepted that neither party was contesting the existence of an employment relationship between Mr. Potter and the Commission, he did so with some hesitation, and only after providing several reasons why such a relationship might not exist. At the hearing in this court, the Commission once again conceded that it was Mr. Potter's employer. Given that this position was accepted by both parties throughout the proceedings, I agree with Chief Justice Drapeau that it would be unfair to recast the case and dispose of the appeal on a ground that has not been pursued by the Commission. That said, I do not share Chief Justice Drapeau's hesitation in reaching this conclusion. I find, in light of the common employer doctrine, that the Commission was in fact Mr. Potter's employer for the purposes of this case, and that it was therefore correctly designated as the defendant to Mr. Potter's action. Although it is true that under the Legal Aid Act, the Lieutenant Governor and Council retains the formal power of appointment, reappointment, and termination of the Executive Director, the power of appointment is fettered by an obligation to appoint the person nominated by the Commission's Board of Directors. The Board is also responsible for establishing the terms and conditions of the Executive Director's appointment. In addition, it has the authority under Section 39(6) to attribute duties and powers to the Executive Director, an authority that, according to the courts below, includes the power of suspension. These powers conferred on the Board, including its nomination power, which gives it effective control over the Crown's power of appointment, cover nearly all aspects of the employment relationship. Chief Justice Drapeau suggested that the Board's lack of authority to formally terminate the Executive Director might undermine Mr. Potter's claim, but such a conclusion would conflict with the common employer doctrine and with the law applicable to constructive dismissal. I accept that the Commission was Mr. Potter's employer for most purposes, even though the Crown was his employer for the purpose of formal appointment, reappointment, and termination. What a finding of constructive dismissal requires is not formal termination, but a unilateral act by the employer to substantially change the contract of employment. As is clear from the wide-ranging powers discussed above, The Commission has the power to alter fundamental aspects of the Executive Director's contract of employment, and thus to constructively dismiss him. To conclude otherwise would be to allow a permissible complexity in organizational arrangements to work an injustice by undermining the legitimate expectations of wrongfully dismissed employees. It would protect an employer from liability for acts amounting to constructive dismissal on the basis that it lacked the power to formally terminate the employee. 2. Can the words of the contract be interpreted to mean that it established an express grant of authority to suspend Mr. Potter for administrative reasons? If the Commission had the authority under the contract to suspend Mr. Potter for the administrative reasons it gave, then the contract was not breached and Mr. Potter's constructive dismissal claim must fail. The express terms of the contract are found in the Legal Aid Act and in the terms and conditions of employment established by the Board pursuant to Section 39(2) of the Act. The possibility of suspension is not mentioned in the terms and conditions, nor does the Legal Aid Act refer to suspension. However, Section 21(1) of the Interpretation Act reads as follows. 21(1) Words authorizing the appointment of a public officer, including the power A. of removing or suspending him, B. of reappointing or reinstating him, C. of appointing another in his stead or to act in his stead, and D. of fixing his remuneration and varying or terminating it, in the discretion of the authority in whom the power of appointment is vested. At trial, Mr. Potter argued that this provision should be applied in interpreting Section 39(1) of the Legal Aid Act, which provides that the Lieutenant Governor and Council shall appoint as the Executive Director of Legal Aid the person nominated by the Board. He submitted that, since these are words authorizing the appointment of a public officer, the power of suspension lies not with the Board, but with the Crown, and that the Board therefore lacked the authority to suspend him for administrative reasons. The trial judge disagreed, relying on Section 39(6) of the Legal Aid Act, which I reproduce here once again for convenience. 39(6) The Executive Director shall perform the duties and may exercise the powers imposed on the Executive Director by this part, the regulations, or the Board. According to Justice Grant, the Board's general supervisory powers referred to in Section 39(6) include the power to suspend and replace the Executive Director. Were this not the case, if the Executive Director were to become ill or otherwise incapacitated, the Commission would be unable to function unless the Lieutenant Governor and Council appointed a replacement. Justice Grant found that such an outcome would run counter to the primary purpose of the Legal Aid Act, which is to establish a functioning legal aid plan. The Court of Appeal gave additional reasons in support of this interpretation of the contract. Chief Justice Drapeau pointed out that Section 11A of the Interpretation Act provides that the Interpretation Act applies in this case only if it is not inconsistent with the intent or object of the Legal Aid Act. Section 39 of the Legal Aid Act does not merely consist of words authorizing the appointment of a public officer. It goes further than that, in that it grants additional powers to the Lieutenant Governor and Council, the Board, and the Executive Director, and Section 21(1) of the Interpretation Act is inconsistent with the provisions establishing some of those powers. For instance, Section 39(5) of the Legal Aid Act fetters the Lieutenant Governor and Council's reappointment power, and Section 39(2) grants the Board the authority to establish the terms and conditions of the Executive Director's appointment, including remuneration. Section 21(1) of the Interpretation Act is inconsistent with both of these provisions. Even if the Interpretation Act did apply, Chief Justice Drapeau suggested that the power of suspending provided for in Section 21(1)A is limited to disciplinary measures, since that word is used in conjunction with removing. In my view, for the reasons given by Justice Grant and by Chief Justice Drapeau, the Legal Aid Act comprehensively sets out the various powers applicable to the Executive Director's contract of employment, and the Interpretation Act is inconsistent with some of the provisions establishing those powers. The Lieutenant Governor and Council's power of appointment does not necessarily include the power of suspension, and even if it did include that power, I agree that the power of suspension contemplated in Section 21(1)A of the Interpretation Act is limited to disciplinary suspension. As a result, any power to suspend the Executive Director for administrative reasons can only lie with the Board. I also agree with Justice Grant that Section 39 of the Legal Aid Act attributes to the Board jurisdiction over all aspects of the Executive Director's employment, except for his or her formal appointment or reappointment and the formal revocation of an appointment, and that the Board's jurisdiction in this regard includes establishing the terms and conditions of the appointment and directing the Executive Director in the performance of his or her duties and the exercise of his or her powers. That being said, these broad powers conferred on by the Board do not expressly include the power of suspension for administrative reasons. I will now turn to the question whether such a power can be found to be implied in the contract of employment. 3. Was there an implied grant of authority to suspend Mr. Potter for administrative reasons? Since there was no express grant of authority to suspend Mr. Potter for administrative reasons, any such authority would have to be found to be implied in the contract. This requires us to inquire into whether the Board's authority under Section 39(6) of the Legal Aid Act to attribute powers and duties to the Executive Director includes the authority to suspend Mr. Potter indefinitely with pay for the administrative reasons the Board gave. In my view, it does not. In reaching the opposite conclusion, the trial judge was led astray by an incorrect articulation of the law applicable to administrative suspensions. Justice Grant erred in finding that the Commission did not have a duty to provide Mr. Potter with work, and as a result he failed to inquire into whether it had discharged its burden by showing that the suspension was justified. For the reasons set out below, I conclude that the Commission did not discharge that burden, and that as a result, the suspension was unauthorized. Admissibility of evidence adduced to prove that an act constitutes constructive dismissal. The onus is on the employee to prove that an act constitutes constructive dismissal. The employee must prove on a balance of probabilities that the employer's unilateral act breached the contract, and that that breach substantially changed the essential terms of the contract. As I mentioned above, the evidence produced to establish that the breach was substantial must be assessed from the perspective of a reasonable person. The test is whether, at the time the breach occurred, a reasonable person in the same situation as the employee would have felt that the essential terms of the employment contract were being substantially changed. In the instant case, the trial judge, purporting to apply the test above, commented as follows, quote, "It is necessary in my view that I only consider what Mr. Potter knew at the time he alleges he was constructively dismissed, because he could hardly agree that he was constructively dismissed based on something the employer did ubernost to him. For example, he was not aware of the letter to the Minister of Justice at the time. He can't therefore say that by sending the letter the defendant repudiated the contract and thereby constructively dismissed him." End quote. The Court of Appeal questioned the trial judge's conclusion on the issue, stating that it may be that the trial judge was required to consider all of the circumstances, including those unknown to Mr. Potter prior to commencing his action. However, Chief Justice Drapeau said that such an error would have been wholly harmless, because even if Justice Grant had considered the excluded evidence, that evidence would only have confirmed the view that the Board had acted in a manner consistent with its obligations under the contract, given that it could not itself terminate Mr. Potter. With respect, I am of the view that the trial judge was indeed in error, and that this error was not harmless. The error stemmed from a failure to make a distinction between the individual steps of the test for constructive dismissal. As I mentioned above, this court's test from Farber has two parts. Justice Grant should have begun by asking whether, from an objective viewpoint, a breach of the contract had occurred. It was only after determining that a breach had in fact occurred that he should have proceeded to the second step, that of determining whether the breach was a substantial one. It is at this second stage of the analysis that the perspective shifts, and that what is relevant is what is known by the appellant at the time of the breach, and what ought to have been foreseen by a reasonable person in the same situation. The trial judge failed to deal with the first step of the test. This shift in perspective demonstrates the balance that is struck in the doctrine of constructive dismissal. On the one hand, the doctrine is based on a recognition that the employee is a vulnerable person vis-à-vis the employer. However, the ensuing accommodations are not unlimited. Accordingly, the perspective at the second step of the first branch of the test, at which the issue is whether the breach was substantial, and in the second branch of the test is that of a reasonable person in the same circumstances as the employee. There is no requirement that the employer actually intend no longer to be bound by the contract. The question is whether, given the totality of the circumstances, a reasonable person in the employee's situation would have concluded that the employer's conduct evinced an intention to no longer be bound by it. However, with respect for Justice Cromwell's opinion, the perspective here cannot be stretched so far as to allow the employee to rely on grounds that, although real, were unknown to him or her at the relevant time. Such an approach would risk encouraging disgruntled employees who have quit their jobs to allege constructive dismissal and engage in fishing expeditions against their employers in hope of identifying evidence to support their claims. In the instant case, as the first step of the branch of the constructive dismissal analysis, the trial judge was required to inquire from an objective viewpoint into whether the administrative suspension amounted to a breach of contract. To exclude evidence such as the evidence excluded by the trial judge in this case would be to make the employee's right to claim constructive dismissal depend on whether the employer was artful enough to conceal his state of mind. As I mentioned above, the question whether a suspension amounts to a breach will often require a more careful analysis than might be necessary in constructive dismissal cases involving other types of changes. This is because, unlike with such unilateral changes as a demotion, a reduction in wages, or a modification to the pay structure, an employer's ability to suspend an employee can be found to be implied in the contract. The court must therefore determine whether the suspension was implicitly authorized by the contract. In Carscallon and FRI Corporation, for example, the Ontario Court of Appeal, in inquiring into whether an employee's disciplinary suspension amounted to a breach, considered multiple factors, including the facts that the suspension was without pay and that it was indefinite. A similar approach was taken in Labar and Spear Omega Incorporated, in which the Quebec Superior Court also considered a notice sent to other employees to inform them of the suspension, as well as the revocation of a company credit card and the use of a vehicle. When faced with a unilateral change by the employer, the employee is placed in the unenviable situation of having to decide whether to accept the change or to resign and bring an action for constructive dismissal. This life-altering decision must be made in circumstances in which the information available to the employee is limited, and there is an imbalance of power between the employee and the employer. As was made clear in Farber, it would be unfair to rely on information that undermines the employee's claim and that the employee did not know about or could not have been expected to have foreseen. In Farber, as I mentioned above, Justice Gontier first determined that a breach had occurred. The employee had been confronted with a unilateral change that involved a significant, even a serious demotion. He then inquired into whether the demotion constituted a substantial change to the essential terms of the employment contract. The employer argued that because the commission the employee would have actually earned in the new position had turned out to be higher than the amount he would have earned had he remained in the former position, the demotion did not constitute a substantial change. Justice Gontier held that this evidence should be excluded, however, on the basis that a court must not, in determining whether a breach is substantial, consider evidence consisting of information that was neither known to the employee nor reasonably foreseeable. The reason why the evidence was excluded in Farber does not apply in the instant case. In Farber, the court excluded the evidence in question not in determining whether a breach had occurred, but in determining whether the change was substantial. This distinction has a significant impact on the determination of whether evidence is relevant. The board's letter recommending that Mr. Potter's employment be terminated for cause is plainly relevant to the circumstances at the time of the alleged breach. Also, as I will explain in the next section, the employer's intentions are relevant to the determination of whether the suspension was wrongful, which is the key issue in Mr. Potter's constructive dismissal action. The exclusion of the evidence was therefore far from wholly harmless. It deprived the trial judge of evidence that was relevant to the central issue of the case. Characterizing Mr. Potter's suspension. The broad question of an employer's right to temporarily discontinue an employee's work in a non-unionized workplace has been the subject of much debate. Before addressing the question whether the board had the authority to suspend Mr. Potter as it did in this case, I wish to make it clear that certain points are not at issue in this appeal. First, this case does not concern a layoff for economic reasons. Because Mr. Potter's salary and benefits continued to be paid, he was not laid off, and the question of an implied authority to lay employees off temporarily does not arise. Second, this case does not concern an administrative suspension for reasons unrelated to the employee's conduct. In Quebecman, this court drew a distinction, albeit in the civil law context, between extrinsic and intrinsic factors that might support a finding that an administrative suspension is justified. Some possible extrinsic factors are financial difficulties, a shortage of work, technological change, or reorganization of the business, but no such factors are alleged in the case at bar. Rather, the decision to suspend Mr. Potter was based on intrinsic factors in that it related to the actions of Mr. Potter himself. Third, this case does not concern a disciplinary suspension. Although the board privately recommended in its letter to the Minister of Justice, and gave reasons for doing so, that Mr. Potter's appointment be revoked for cause, it did not suspend Mr. Potter for disciplinary reasons. The parties agree, as did the courts below, that by directing Mr. Potter to stay home and delegating his powers to someone else, the board placed him on an administrative suspension. In this court, the Commission conceded that the suspension was administrative and not disciplinary. Questions related to an implied authority to suspend an employee for disciplinary reasons, or an implied obligation to impose a lesser sanction such as suspension where there is cause for dismissal, does not arise. Incidentally, given that cause was not alleged in the instant case, I question the relevance of the Court of Appeal's lengthy summary of what it calls the deterioration of Mr. Potter's relationship with the board. Chief Justice Drapeau stated that he was including this evidence to show the board's revocation recommendation was bona fide and anything but frivolous. However, these facts had not been litigated at trial, and they consisted mostly of unproven allegations that had been made by the Commission. Unless they relate to the specific administrative reasons given by the board for suspending Mr. Potter, they are not relevant. The question I must answer is whether the board had an implied authority to suspend Mr. Potter indefinitely with pay for the administrative reasons it gave. It should be noted that the board gave no reasons when it suspended Mr. Potter on January 11, 2010. When asked for clarification the next day, the board simply confirmed that Mr. Potter was not to return to work. There were no further communications between the board and Mr. Potter until he commenced his action for constructive dismissal on March 9, 2010. The trial judge found that the reason for the suspension had been to facilitate the negotiation of a buyout of Mr. Potter's contract. Because Mr. Potter had met with the board in the spring of 2009 to discuss a buyout, the board had every reason to believe that he was interested in a buyout of his contract. In light of the ongoing negotiations, an administrative suspension pending their resolution is entirely consistent with what the parties' relationship was at the time. Justice Grant went on as follows, quote, "In my view, the Commission's directive that he was not to come to work merely reflected what Mr. Potter already knew and indicated he would accept if the terms were right, viz. That the Commission wanted to buy out his contract. It also ensured that nothing would occur that might complicate the settlement negotiations. There is no evidence that the board advised him that they intended to arrange for his termination. On the evidence before the court, I find that he made his dramatic move of starting legal action against his employer in response to no unilateral act by the employer that could be construed by a reasonable person as repudiation of the contract. He was still being paid his full salary and benefits, and if, as he says, he was feeling the pressure of the uncertainty of his situation, he only had to create a paper trail asking for clarification." End quote. Even if I were to adopt Justice Grant's characterization of the Commission's reasons for suspending Mr. Potter, I would nevertheless find that the board lacked the authority to suspend Mr. Potter indefinitely with pay to facilitate the negotiation of a buyout of his contract. I will now address the Commission's main argument that it had no duty to provide Mr. Potter with work. Before doing so, however, I would note that the board did not merely withhold work from Mr. Potter. It ordered him to stay away from the office and designated a replacement. Moreover, even if the board had an implied authority to relieve Mr. Potter of some or all of his statutory duties, it is my view that such an authority is not unfettered, but is subject to a basic requirement of business justification. Because no legitimate business reasons were given in this case, I find that the suspension was unauthorized. The Commission had a duty to provide Mr. Potter with work. In the Commission's view, the question is not whether it had the authority to suspend Mr. Potter, but whether it had a duty to provide him with work. Since most employment contracts did not impose such an obligation, and since there was traditionally no general common law duty to provide work, the Commission submits that an administrative suspension with pay would only rarely constitute a breach of contract. The traditional common law principle was that the obligation to keep an employee retained and employed did not necessarily import an obligation on the part of the employer to supply work. There are recognized exceptions to this principle. One exception relates to contracts of employment where there is a benefit to the employee, such as an actress or a radio or television performer, from the performance of the work. A second is where the employee's remuneration is by commission. However, the trial judge held, and the Commission argues, that these exceptions do not apply in the case at bar. In Park, a company's president and CEO was given notice of termination and ordered not to go to the office during the notice period. The court found that both of the exceptions applied. First, part of Mr. Park's remuneration was in the form of a bonus, and, second, he derived a reputational benefit from the performance of his work in that as the chief executive officer, he was primarily responsible for the operations of the company, and the success or failure of the company was a reflection of his performance in that role. Mr. Park's suspension was accordingly found to be wrongful, and he was awarded damages. The opposite result was reached in Sulman and BC Research Council, in which an administrative assistant was given notice of termination on the basis of insufficient work. Because no attempt had been made to show that Ms. Sulman's circumstances fell under either of the exceptions to the traditional rule, there was no obligation to provide her with work, and the reduction of her workload during the notice period was found not to be wrongful. In the case at bar, Justice Grant distinguished Park on the basis that it had involved not a suspension, but a complete removal of Mr. Park's duties and powers, whereas this case does involve a suspension, one that was imposed pending the resolution of negotiations aimed at buying out Mr. Potter's contract. With respect, I find this distinction unpersuasive. Although Mr. Potter was not paid by commission, he was the executive director of a government program whose success, like that of the company run by Mr. Park, was associated with his performance. I have no doubt that Mr. Potter derived a reputational benefit from the performance of his work. Justice Grant seemed to suggest that Mr. Park's suspension was more troubling because it was for a finite period, the period of his notice of termination. But in my opinion, the opposite is true. The indefinite duration of Mr. Potter's suspension created uncertainty that exacerbated the impact of the suspension. In both cases, the employee was directed to stay away from the office and was replaced for the duration of the suspension. Finally, whereas Mr. Park's powers and duties had been assigned to him solely by the company's directors, those of Mr. Potter were set out comprehensively in the Legal Aid Act. His suspension made it impossible to fulfill numerous statutory obligations. Mr. Potter recognized this when his counsel requested clarification of the suspension. Quote, "Given that Mr. Potter occupies a position which sets out a statutory obligation to perform the duties of his position, can you confirm whether the board has suspended Mr. Potter?" End quote. In short, by arguing that it did not have a duty to provide Mr. Potter with work, the Commission effectively denies that he was suspended on the basis that no term of the contract was changed. For the above reasons, the nature of the executive director's position and the detail in which Mr. Potter's obligations were defined in the contract, I cannot accept the view that the board had no obligation to provide Mr. Potter with work. For the reasons that follow, however, I would prefer not to rest my conclusion solely on the particular features of Mr. Potter's employment situation. An employer's authority to withhold work is never unfettered. In my view, even if the exceptions under which an employer would be required to provide an employee with work do not apply. The employer does not have an unfettered discretion to withhold work. To the extent that the proposition that the employer's discretion is absolute was ever valid, it has been overtaken by modern developments in employment law. Work is now considered to be one of the most fundamental aspects in a person's life, providing the individual with a means of financial support and, as importantly, a contributory role in society. A person's employment is an essential component of his or her sense of identity, self-worth, and emotional well-being. Thus, it is clear that the benefits derived from performing work are not limited to monetary and reputational benefits. Although I accept that employees who receive earnings from commission or who derive reputational benefit from the performance of their work are placed at a particular disadvantage should their employers refuse to provide them with work, and that this justifies finding that an obligation to provide work is implied in the contract, I would caution against assuming that the converse is also true, namely that workers who are not included in those narrow categories derive no benefit whatsoever from the performance of their work, and that their employers therefore have an unfettered discretion to suspend them with pay. Is it really the case that a president and CEO has, by virtue of his or her reputation, an implied right to work, whereas an administrative assistant, because his or her reputation is not valued, lacks any such right? In my view, the trial judge, in taking this category-based approach, on which the Commission relies, pays insufficient attention to the role of proportionality and balancing in modern employment law. Even at common law, where the employer is not under a general obligation to provide work, the employer may not withhold work in bad faith or without justification. It may reduce an employee's workload or abolish his or her position for legitimate business reasons, as was done in Sulman, in which the employee's workload was reduced pending her termination owing to a shortage of work. However, I reject the proposition that an employer can refuse to provide work to an employee to whom the exceptions discussed above do not apply, let alone suspend and replace such an employee for just any reason. That would undermine the non-monetary benefit all workers may in fact derive from the performance of their work. It would also be inconsistent with the employer's duty of good faith and fair dealing that has been gaining acceptance in common law. To summarize, it is not true that one category of employees benefits from a duty to provide work that means that a suspension with pay amounts to constructive dismissal, whereas suspension with pay is authorized for another category of employees that benefits from no such duty. The determination will be fact-specific in each case. The common law exceptions remain useful as indicators that an employer has implied contractual obligations. For employees who receive earnings from commissions or who derive a reputational benefit from the performance of their work, suspension with pay will constitute a direct breach of an implied contractual term. That being said, no employer is at liberty to withhold work from an employee either in bad faith or without justification. The question is whether, in the circumstances of the particular case, the employer has demonstrated that the administrative suspension of the employee with pay is justified. An administrative suspension must be both reasonable and justified. Courts have developed a number of approaches to determining whether an administrative suspension is authorized by a contract. None of them apply directly to the situation in this case, but the principles on which they are all based are relevant. In my view, common threads can be identified in this court's multi-factored approach in Quebec to the administrative suspension of an employee against whom criminal charges were pending in Quebec, the approach to the same issue taken by courts in the common law provinces, and the approach adopted by the New Brunswick Court of Appeal in the case at bar. All of the courts in question have imposed on the employer a basic requirement of good faith business justification. The factors they have applied include, but are not limited to, the existence of legitimate business reasons, good faith, the duration of the suspension, and whether the suspension was with pay. All the relevant factors go to the fundamental question whether the employer's decision to suspend was both reasonable and justified in the circumstances. As was made clear in Quebecman, it is the employer that bears the burden of establishing that the suspension satisfies these two criteria. In Quebecman, This court addressed, albeit in a civil law context, the scope of an employer's authority to impose an administrative suspension on an employee against whom criminal charges have been laid. The court defined the employer's residual power to suspend as follows. Quote, this residual power to suspend for administrative reasons because of acts of which the employee has been accused is an integral part of any contract of employment, but is limited and must be exercised in accordance with the following requirements. 1. The action taken must be necessary to protect legitimate business interests. 2. The employer must be guided by good faith and the duty to act fairly in deciding to impose an administrative suspension. 3. The temporary interruption of the employee's performance of the work must be imposed for a relatively short period that is or can be fixed, or else it would be little different from vacillation or dismissal pure and simple. And 4. The suspension must, other than in exceptional circumstances that don't apply here, be with pay. End quote. In Quebecman, the employee, a sales manager, had been charged with conspiracy to extort money from his securities broker, and after pleading not guilty to the offense, was suspended by his employer without pay pending resolution of the charges. The suspension was found to have been justified as the employer had imposed it for legitimate business reasons relating to the company's image and reputation. However, the employer could not justify its decision not to pay the employee during the suspension period. Quote, in the context of a suspension that at all times remained administrative in nature, there was no reason to refuse to pay the salary of an employee who remained available to work. End quote. The court did not hold that an employer that pays its employee during the period of an administrative suspension need not show that the suspension is justified. Even if an employee is suspended with pay, it may be that the suspension will ultimately be treated as a unilateral rescindation of the contract if the end result is not the reinstatement of the employee. Also, the initial suspension can turn into a constructive dismissal or be regarded as one because of its length or because of an indefinite or excessive extension. The court emphasized that its reasoning applied in the context of the Civil Code of Quebec, which includes the following reciprocal obligations. Quote, the employer agrees to allow the employee to perform the work agreed upon, to pay the employee remuneration, and to take any necessary measures to protect the employee's health, safety, and dignity. The employee is bound to carry out his or her work with prudence and diligence and to act faithfully and honestly towards the employer. End quote. The same reasoning cannot therefore be applied routinely to contracts in the common law context, as the same obligations do not exist at common law. That being said, in Farber, the leading authority on constructive dismissal, and a case that had originated in Quebec, Justice Gonthier had noted at paragraph 35 that the law of constructive dismissal in Quebec is similar to that of the rest of Canada. Quote, thus, although decisions from the common law provinces are not authoritative, it may be helpful to refer to them to see what types of changes the courts have considered fundamental changes to an employment contract resulting in the termination of that contract. End quote. Likewise, the principles underlying the court's analysis of administrative suspensions in Quebecman were drawn from a large body of arbitral jurisprudence that has influenced both common law and civil law employment norms. In that case, the court referred, inter alia, to the Quebec case of Sûreté du Québec et Association des Policiers Provinciaux du Québec, in which an arbitrator, citing Fraternité des Policiers de la Communauté Urbaine de Montréal et Communauté Urbaine de Montréal, in which another arbitrator, relying on DJM Brown and DJM Beattie in Canadian Labour Arbitration, the leading Canadian authority on labour arbitration, stated, quote, in assessing the appropriateness of a suspension pending trial, rather than inquiring into the guilt or innocence of the accused employee, arbitrators will attempt to determine whether the effects of the alleged offense on the employment relationship are such that continuation of the employment pending the decisions of the competent authorities would create sufficient serious and immediate risk, contrary to the employer's legitimate interests, which encompasses the employer's financial integrity and safety and security of its property and of the other employees, and its reputation. In the common law provinces, as in Quebec, courts have begun to apply the principles discussed above in the context of non-unionized workplaces by imposing a basic requirement of business justification on an employer that suspends an employee for administrative reasons. In one case, Reininger and Unique Personnel Canada Incorporated, a truck driver was suspended without pay for a 90-day period during which his driver's license was to be suspended, and then until after his trial on criminal charges. After finding that an authority to suspend was implied in the contract on the basis of company policy and practices, as well as other factors, Justice Howden inquired into whether the suspension was reasonable or justified. Finding that no framework had yet been developed by common law courts, he drew factors from arbitral jurisprudence on the same question, and in particular from a test adopted in Re Ontario Jockey Club and Mutual Employees Association Services Employees International Union, Local 528, and adapted them to the case before him. He synthesized the factors as follows. 1. The onus is on the employer to demonstrate to the court on a civil standard of proof that a reasonably serious and immediate risk to employers' legitimate business interests. The employer must establish that the nature of the charge is such as to be potentially harmful to the employer's reputation or product, or that it will render the employee unable to properly perform his duties, or that it will have a harmful effect on its employees or customers. 2. The employer must show that it made a genuine attempt to assess the risk of continuing employment, including making its own investigation or inquiry. The fact that the police have investigated the matter and have acquired the evidence to lay the charge significantly lessens the burden of the investigation on the employer. 3. The employer must also show that it has taken reasonable steps to ascertain whether the risk of continued employment might be mitigated through such techniques as closer supervision or transfer to another position. 4. There is a continuing onus on the employer during a period of suspension to consider objectively the possibility of reinstatement within a reasonable period of time following suspension in light of new facts or circumstances that may come to its attention. On the facts of the case before him, Justice Howden found that the suspension without pay was justified for the 90-day period during which the employee's driver's license was suspended and no other position was available. However, he considered it unreasonable for the employer to have imposed a further suspension pending the outcome of the employee's criminal trial. Although the tests from Reininger and Kabakeman were developed in the context of different legal systems, they both incorporate principles from the collective bargaining context and are as a result quite similar. For the determination of whether a suspension is justified, both tests focus on a need for legitimate business reasons, good faith, and a minimal impact in terms of duration. As I mentioned above, the test relied on by the Court of Appeal in the instant case was taken from Devlin. In that case, the employee, the president and CEO of a company, had been suspended by a newly elected slate of directors who were dissatisfied with his management record. Justice Silverman, citing Pierce and Canada Trust Realtor and McKay and Avco Financial Services Canada, set out the following list of factors, reproduced here once again for ease of reference, to consider in determining whether a suspension of an employee amounts to a constructive dismissal. 1. The duration of the suspension. 2. Whether someone was appointed to replace the suspended employee. 3. Whether the employee was asked for his or her keys. 4. Whether the employee continued to be paid and received benefits. 5. Whether there is evidence that the employer intended to terminate the employee at that time. And 6. Whether the employer suspended the employee in good faith, for example, for bona fide business reasons. The court also noted, citing Carscallon, at paragraph 34, that a suspension with pay is less likely to be found to amount to a constructive dismissal than one without pay. Although Devlin did not involve a suspension pending the resolution of criminal charges, these factors, like the ones considered in Kabakeman and Reininger, focus on a need for legitimate business reasons, good faith, and minimization of the duration of the suspension. As in Kabakeman, the Devlin factors also emphasize the importance of the employees being paid during the suspension period. In my view, the additional factors in the test from Devlin are consistent with the approach taken in Kabakeman and Reininger, and they help answer the fundamental question whether the suspension was reasonable and justified. For instance, the appointment of a replacement would suggest that the suspension was not temporary and would rule out certain possible business reasons, such as a shortage of work. Requiring that the employee turn in his or her keys would suggest a degree of permanence to the change and would indicate that the reasons for suspension were more likely related to the employee's conduct than to extrinsic business concerns. The Commission has failed to establish that the suspension was reasonable or justified. I do not find it necessary to articulate a rigid framework for determining whether a particular administrative suspension is wrongful. The approach to be taken and the factors to be considered will depend on the nature and circumstances of the suspension. The overriding question will be whether the suspension was reasonable and justified. That said, it is clear from the above discussion that certain factors, while they may not be necessary, will always be relevant. These factors include the duration of the suspension, whether the suspension is with pay, and good faith on the employer's part, including the demonstration of legitimate business interests. In my view, legitimate business reasons constitute a requirement for a finding that an administrative suspension based on an implied authority to suspend is not wrongful. Other than in the context of disciplinary suspension, an employer does not, as a matter of law, have an implied authority to suspend an employee without such reasons. Legitimate business reasons must always be shown, although the nature or importance of those reasons will vary with the circumstances of the suspension. In the instant case, this basic requirement was not met. To begin with, Mr. Potter was given no reasons for the suspension. It seems to me that in most circumstances, an administrative suspension cannot be found to be justified in the absence of a basic level of communication with the employee. At minimum, acting in good faith in relation to contractual dealings means being honest, reasonable, candid, and forthright. Failing to give an employee any reason whatsoever for this suspension is, in my opinion, not being forthright. Moreover, the limited evidence presented in supporting the board's ostensible purpose of facilitating a buyout is undercut by the actions the board took to have Mr. Potter terminated. As I mentioned above, the board's resolution of January 5, 2010, and the January 11, 2010 letter to the minister in which the board recommended that Mr. Potter be terminated ought to have been admitted at this stage of the analysis. With respect, this constituted a significant error on the trial judge's part. Add to this the facts that Mr. Potter was replaced during the suspension period, and that period was indefinite, and there remains no doubt in my mind that the suspension was unauthorized. To reiterate, which factors must be considered will vary with the context and will depend on the nature and circumstances of the suspension. The Court of Appeal applied the Devlin factors in upholding the trial judge's decision. I find that in doing so, it overemphasized the fact that the suspension was with pay, underemphasized the absence of legitimate business reasons, and disregarded the evidence of the board's intention to terminate Mr. Potter. Even where an administrative suspension is with pay, an employer must still meet the basic requirement of a good faith business justification. The Commission has not shown that the suspension in this case was reasonable and justified. I would stress that, on the evidence, it cannot be said that Mr. Potter acquiesced in this change. Even if Mr. Potter was interested in a buyout, that interest can in no way be taken as consent to his suspension, nor can it be prejudicial to his position in his action, as the trial judge seemed to imply. In my opinion, Mr. Potter simply did what most employees would do if their employer raises the possibility of a buyout. Listen to the offer, and depending on its terms, consider accepting it. I wish to go back for a moment to situate the analysis within the framework of the test for constructive dismissal. The fact that the suspension was unauthorized establishes that a breach of the employment contract has occurred. Because the board has failed to establish that the suspension was reasonable or justified, it cannot argue that it was acting pursuant to an implied term of the contract, which means that the suspension constituted a unilateral act. Mr. Potter has accordingly discharged his burden at the first step of the analysis. As I explained above, whether a breach has occurred must be determined objectively, and what a reasonable person in the employee's circumstances would have known or ought to have foreseen is not relevant at this step. As I also explained above, in a constructive dismissal case involving an administrative suspension, the burden shifts to the employer to show that the suspension was reasonable. With respect, the trial judge therefore erred in placing the burden on Mr. Potter to show that it was unreasonable. And he also erred in conflating the first and second step of the constructive dismissal analysis, and in restricting evidence of the existence of the breach to what Mr. Potter knew or ought reasonably to have foreseen at the time of the unilateral act. The unauthorized suspension amounts to constructive dismissal. Having established that the suspension was unauthorized and therefore amounted to a breach of the employment contract, Mr. Potter must also satisfy the criteria of the second step of the first branch of the test for constructive dismissal. As I mentioned above, what must be determined at this step is whether at the time of the suspension, a reasonable person in the same situation as Mr. Potter would have felt that the essential terms of the employment contract were being substantially changed. It is at this stage of the analysis that the fact that Mr. Potter neither knew about nor could reasonably have been expected to know about the letter recommending the termination of his employment becomes relevant, and that letter must accordingly be excluded. As I will explain below, however, the exclusion of the letter does not affect the outcome of the analysis. It was reasonable for Mr. Potter to perceive the unauthorized unilateral suspension as a substantial change to the contract. As far as he knew, he was being indefinitely suspended and had been given no reason for the suspension. The letter to Mr. Potter stated that the suspension was to continue until further direction from the Commission. When Mr. Potter had his lawyer write to request clarification of the board's instructions, the board persisted in its silence regarding the reason and simply stated that he is not to return to work until further notice. In my opinion, that is sufficient to discharge Mr. Potter's burden here. Knowledge of the reasons given by the Commission at trial should not be imputed to Mr. Potter as of the time of the suspension. I would suggest that in most cases in which a breach of an employment contract results from an unauthorized administrative suspension, a finding that the suspension amounted to a substantial change is inevitable. If the employer is unable to show the suspension to be reasonable and justified, there is little chance, to my mind, that the employer could then turn around and say that a reasonable employee would not have felt that its unreasonable and unjustified acts evinced an intention to no longer be bound by the contract. Any exception to this rule would likely arise only if the unauthorized suspension was of particularly short duration. B. Repudiation by the employee. Because I have now concluded that Mr. Potter was constructively dismissed, the question whether the bringing of his action for constructive dismissal amounted to a resignation does not arise. The contract had already been repudiated by the board. Although the courts below ruled on this issue and submissions were made on it in this court, it would in my view be inadvisable to reach any conclusions with respect to the resignation of an employee in the absence of circumstances requiring me to address the issue. I would note, however, that in many failed constructive dismissal cases, the reason why the question of resignation by the employee does not arise will be that it is clear that the employee has resigned, given that, after the employer acted unilaterally to, for instance, demote the employee or transfer him or her to a new position, the employee elected to quit work and sue the employer. In this typical situation, if the constructive dismissal action fails, the employee cannot then argue that he or she did not quit work. Nevertheless, there are instances in which it will not be necessary to conclude that the employee has resigned in bringing the constructive dismissal suit. One such case would be where, following the changes to the contract, the employee has continued to work under protest. This court has held that employees have a duty to mitigate their damages by remaining in the workplace, provided that doing so would not be objectively unreasonable. Where the employment relationship has not become untenable, it is not evident that by commencing legal action, the employee should be held to have resigned by operation of law. In the case at bar, the unilateral change by the employer was an indefinite suspension with pay. After the suspension had continued for approximately 8 weeks, Mr. Potter sued for damages for constructive dismissal. He did not, as has happened in other cases, clearly resign, given that he had already stopped performing his duties while continuing to be paid, and that, in his view, the fact that he continued to work, i.e. that he remained on suspension with pay, was consistent with the position he was taking in his constructive dismissal action. The board, of course, viewed Mr. Potter's action as a resignation and promptly cut his salary and benefits. Were I to uphold the trial judge's decision that Mr. Potter was not constructively dismissed, I would then have to determine whether Mr. Potter resigned when he commenced his action for constructive dismissal or was wrongfully terminated by the board when it cut his salary and benefits. The courts below took the view, as does the Commission, that a resignation has been effected by operation of law. In Suman, for example, an employee whose workload had been reduced had failed to make out a case of constructive dismissal and was found to have repudiated her contract by the position she took in her statement of claim. This view certainly finds support in the traditional principles of the law applicable to constructive dismissal, and I have no doubt that the employee will be found to have resigned in the majority of failed constructive dismissal cases. However, I will leave it open on the question whether there are factual circumstances in which an employee whose constructive dismissal action is unsuccessful might nevertheless argue that he or she did not resign. C. Deduction of pension benefits. I will now turn to the question whether the pension benefits Mr. Potter received should be deducted from his damages. According to the board's resolution dated December 12, 2005, that established the terms and conditions of Mr. Potter's appointment, the public service superannuation pension plans applied to him. The plan in question is governed by the Public Service Superannuation Act. It is a contributory plan that is not intended to provide compensation to a contributor who has been wrongfully dismissed. The resolution also provided that Mr. Potter was entitled to a regular retirement allowance and special retirement allowance, both of them equivalent to 25 weeks' pay. Section 16 of the Public Service Superannuation Act reads as follows. 16. Where a contributor in receipt of an immediate pension or an annual allowance under this Act, the Superannuation Act, the Teachers Act, or the Teachers Pension Act, becomes employed in full-time employment in the public service, his or her entitlement to such immediate pension or annual allowance is to be suspended effective the date of his or her appointment, and if he or she becomes a contributor under this Act, the period of such reemployment is to be additional pensionable service for the purposes of this Act. In this court, Mr. Potter submits that the trial judge should not have deducted amounts received under the pension plan from the damages to be awarded. He relies on this court's decision in IBM Canada Limited and Waterman, arguing that payments received under a defined benefit pension plan should not be used to reduce damages payable for wrongful dismissal. Mr. Potter argues that Section 16 of the Public Service Superannuation Act should apply only to employees in receipt of pension benefits who return to employment in the public service, and that it does not apply in a wrongful dismissal case. The Commission contends that the trial judge was right to deduct the amounts Mr. Potter had received under his pension plan. In its view, Section 16 of the Public Service Superannuation Act is intended to prevent employees, regardless of the circumstances, from collecting pension benefits at the same time as they are receiving a salary, and thus falls within the exception to the common law rule from Waterman that I will discuss below. This court must decide whether, in accordance with its decision in Waterman, Mr. Potter's receipt of pension benefits should result in a reduction of the damages awarded to him. If the answer to the first question is no, the court must decide whether Section 16 of the Public Service Superannuation Act precludes Mr. Potter from collecting pension benefits in addition to his damages for wrongful termination. Does the compensation principle require that the pension benefits be deducted from Mr. Potter's damages? First of all, I recognize that the trial judge did not have the benefit of this court's decision in Waterman when he decided to deduct Mr. Potter's pension benefits from the award of damages. That case is central to our decision in the case at bar. In Waterman, Justice Cromwell wrote that the general rule is that the contract damages should place the plaintiff in the economic position that he or she would have been in had the defendant performed the contract. However, there are exceptions to this rule. One of them is the private insurance exception, which concerns inter alia pension payments to which an employee has contributed and which were not intended to be an indemnity for the type of loss suffered. Such benefits should generally not be deducted from damages awarded for breach of contract. In Waterman, as in the case at bar, the question was whether pension benefits received by the plaintiff should be deducted from damages that had been awarded to him. There was a clear compensating advantage, as the plaintiff had received both his full pension benefits and the salary he would have earned had he worked. In addition, there was a but-for causal link between the defendant's breach and the plaintiff's receipt of pension benefits. By wrongfully dismissing the plaintiff, the defendant had obliged him to claim those benefits. After carefully reviewing the jurisprudence of this court and of other common law jurisdictions on the deduction of private insurance benefits from damages, Justice Cromwell formulated some general propositions to help in determining whether such benefits should be deducted in a given case. Benefits have not been deducted if A. they are not intended to be an indemnity for the sort of loss caused by the breach, and B. the plaintiff has contributed to the entitlement to the benefit. Benefits have not been deducted where the plaintiff has contributed to an indemnity benefit. Benefits have been deducted when they are intended to be an indemnity for the sort of loss caused by the breach, but the plaintiff has not contributed in order to obtain entitlement to the benefit. Had the trial judge in the instant case had the benefit of Waterman, he would have concluded that Mr. Potter's pension benefits should not be deducted from the damages awarded to him as a consequence of his employer's breach. As I mentioned above, those benefits were not intended to compensate Mr. Potter in the event of his being wrongfully dismissed. The pension plan was a contributory plan. For the foregoing reasons, on the basis of the private insurance exception from Waterman, the pension benefits received by Mr. Potter should not be deducted from the damages to which he is entitled. Does Section 16 of the Public Service Superannuation Act displace the private insurance exception and require the pension benefits to be deducted? Having concluded that the pension benefits should not be deducted from the damages to be awarded to Mr. Potter on the basis of the exception to the common law rule in Waterman, I must now inquire into whether Section 16 of the Public Service Superannuation Act displaces the private insurance exception and precludes Mr. Potter from collecting both his pension benefits and the equivalent of his salary. The Commission argues that Section 16 precludes the application of Waterman. Mr. Potter contends that this section is intended for situations in which a former employee who is receiving pension benefits returns to employment in the public service, and that it therefore neither applies to wrongful dismissal cases nor precludes Mr. Potter from collecting both the full damages amount and his pension benefits. I agree with Mr. Potter. Section 16 of the Public Service Superannuation Act does not require that the pension benefits received by Mr. Potter be deducted from the damages to which he is entitled as a result of his wrongful dismissal. This section applies to a contributor in receipt of an immediate pension or an annual allowance on being appointed to employment in the public service. It therefore prevents a retired employee who returns to employment in the public service from collecting pension benefits while at the same time receiving a salary as an employee. Section 16 does not establish a general bar on the receipt of both a pension entitlement and employment income. More specifically, it does not apply to an employee who has been wrongfully dismissed and is entitled to receive damages as a result of that wrongful dismissal. The basic rule of statutory interpretation is that the words of an act are to be read in their entire context, in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. Furthermore, Justice Iacobucci in Perry Sound Social Services Administration Board and OPSU Local 324 wrote the following about situations in which it is argued that a statutory provision overrides a common law rule. Quote, "To begin with, I think it useful to stress the presumption that the legislature does not intend to change existing law or depart from established principles, policies, or practices. In Goodyear Tire and Rubber Company of Canada and T. Eaton Company, for example, Justice Falteau, as he then was, wrote that a legislature is not presumed to depart from the general system of the law without expressing its intentions to do so with irresistible clearness, failing of which the law remains undisturbed. In Slate Communications Inc. and Davidson, Justice Lemaire, as he then was, wrote that in the absence of a clear provision to the contrary, the legislator should not be assumed to have intended to alter the pre-existing ordinary rules of common law." End quote. The ordinary meaning of the words of Section 16 does not support the assertion that the New Brunswick legislature intended to preclude the rule in Waterman. On the contrary, it supports Mr. Potter's position that this section applies to the situation of a retired employee who returns to employment in public service. It applies to a contributor in receipt of an immediate pension or an annual allowance who becomes employed in full-time employment in the public service. Further, pension benefits are suspended as of the date of his or her appointment. The Commission's position could succeed only if the circumstances in which the section applies, where the contributor becomes employed and as of the date of his or her employment, were disregarded. According to the concise Oxford English Dictionary, appointment means the action or process of appointing someone, while appoint means assign a job or role to. Section 16 of the Public Service Superannuation Act does not therefore apply to an employee who has been wrongfully dismissed and was obliged to claim pension benefits as a consequence of the breach of the employment contract. Where a court decides that a wrongfully dismissed employee is entitled to damages, he or she does not become employed in full-time employment in the public service at the time of the breach. It would be wrong to equate such a decision to an appointment. The court is simply finding that the employee should have continued to be employed by the employer and that he or she is entitled to damages. As for the context of Section 16, there is nothing in the Public Service Superannuation Act to suggest an intention to preclude the receipt of pension benefits in the circumstances covered by the rule from Waterman. Nowhere does the Act say that pension benefits should be deducted from damages awarded to wrongfully dismissed employees. And at no time in the legislative debate leading up to the enactment of Section 16 was it suggested that the section was to apply where an employee is wrongfully dismissed. Moreover, Section 16 has not changed significantly since being enacted in 1966, when it read as follows. Quote, where a contributor in receipt of an immediate pension or annual allowance under this Act, the Superannuation Act, the Teachers Act, or the Teachers Pension Act, becomes employed in full-time employment in the public service, his entitlement to such immediate pension or annual allowance is to be suspended effective the date of his appointment, and if he becomes or would have become, but for the provisions of subsection 2 of section 4, a contributor under this Act, the period of such reemployment is to be additional pensionable service for the purposes of the Act. I therefore conclude that Section 16 of the Public Service Superannuation Act does not override the rule from Waterman and does not preclude Mr. Potter from collecting both the equivalent of his salary and his pension benefits. Part 5. Conclusion. I would answer the questions raised by the appeal as follows. 1. Did the trial judge err in concluding that Mr. Potter was not constructively dismissed? Yes. 2. If Mr. Potter was not constructively dismissed, did the trial judge err in concluding that Mr. Potter resigned when he launched his action in damages? It is unnecessary to answer this question. 3. If Mr. Potter was constructively dismissed, did the trial judge err in finding that the amounts Mr. Potter received under his pension should be deducted from his damages for wrongful dismissal? Yes. Part 6. Disposition. I would allow the appeal with costs throughout, set aside the Court of Appeals judgment, and allow Mr. Potter's action for constructive dismissal. Mr. Potter is entitled to damages for wrongful dismissal as assessed by the trial judge, with the exception that the pension benefits Mr. Potter has already received are not to be deducted from those damages.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.